So first of all, just to be sure that I've covered the universe, is there anything else officially that is on your list today?
I'm not aware of any, Your Honor.
All right, and Mr. Stewart, anything else from your standpoint?
No, Your Honor.
All right, then I propose that we start out with your motion to reconsider, since that goes back as far as anything else. Does that suit you, Mr. Stewart? All right, and you can stay there, or what suits you, you suit yourself.
Your Honor, we're asking that the court respectfully reconsider so much of the order in limine regarding our potential evidence, our defense as to an alternative perpetrator. Deference is given to the court's order, in which the court indicated that defense had not come forward with any credible alternative perpetrator defense evidence, and to that extent we apologize. We could have done that at the last hearing, but I didn't know that we were going to delve as deep into the issue. Your Honor, since the special prosecutor entered the case, we've received a ton of discovery. Some of it had not been provided by the prior prosecutor, and some of it is provided by Mr. Coleman. And I'll give Mr. Coleman credit for providing us with a lot of discovery that has allowed us to raise the specter of an alternative perpetrator defense. It's kind of come in piecemeal, but in the last several months, we've been made aware of more evidence that we could have offered in support of our alternative perpetrator defense. In my motion to reconsider, we noted that the court indicated that there was case law, which we understand, that gives the court guidance as to when the defendant should be allowed to offer evidence as to an alternative perpetrator. Your order did make reference to the fact that, with reference to Lanny Alexander, which we generally threw out there in our motion, there was no evidence that there was some evidence that he was in custody. In our motion to reconsider, we have provided the court with 2 documents that clearly show that Mr. Alexander was not in custody. And they're included as exhibits. In fact, Judge Cunningham had entered an order releasing him from custody at least 4 days prior to the death of Ms. Humphries. The discovery that we've been provided since the mistrial includes 2 witnesses who related to law enforcement that Lanny Alexander had admitted to them on 2 separate occasions that he murdered Chantelle Humphries. The case law that the court cited, which we understand, did not grant or did not provide a bright line test. It just gave the court guidance as to what the court needs to look for before the defense is allowed to go that way as an alternative perpetrator. The court's concerned that we present issues to a jury that is confusing, that would be a waste of time, that lack credibility, speculative. Your Honor, any time someone admits to killing another person, and there's another person being tried for that, we believe that that in and of itself is sufficient reason to allow the defense to go forward with that person as an alternative perpetrator. I don't believe motive, or the lack of a motive, a clear motive, is fatal to our opportunity, Your Honor. We can provide information that he was not in custody, which addressed the court's concern in this order.
Yeah.
And we have at least 2 witnesses. It's up to the jury as to the credibility of these witnesses. But we have 2 witnesses who indicate on 2 separate occasions that Lanny Alexander admitted to killing the black girl in Cadiz. That's one phraseology. And I also alluded to one of the motions to dismiss, I think one of the hearings on the motion to dismiss, in which we provided the court a tape-recorded interview with a cellmate of Lanny Alexander, who indicated that Lanny Alexander told him, while in custody, that he had enough evidence on his brother, the chief of police, to run him out of Cadiz. And we believe that evidence is knowledge that Lanny Alexander murdered Chantelle Humphries. Now, that could be a motive, but we're not prepared to offer that. We think we can argue that. And we can argue it based upon the evidence that we're prepared to present to the court. It's not speculative. So we would ask the court, considering the exhibits that we've introduced, and I don't know if the court, we need to be on record of, but it's in the record.
It is.
We'd ask the court to duly reconsider and to grant our motion or grant our defense as an alternative perpetrator being Lanny Alexander.
All right. Thank you, Mr. Stewart. Mr. Coleman?
Your Honor, we filed obviously a response in this,
Yeah.
which is based more on the law. And that's those cases that we cited, Beatty, that was originally cited in our earlier motion and as well in our response, was very clear with regard to what is required in these type of situations of an alternative perpetrator. It requires more than just speculation, and that's all really the defense is offering, that there was some speculation of any connections between Lanny Alexander and his brother and Chantelle Humphries. They offer no testimony that would give any direct evidence of any motive of anything between Lanny Alexander or even his brother Hollis and Chantelle Humphries. So really, to throw that out there is only to offer speculation. With regard to statements in jail, we also provided very clear case law on that you got to have something more than some inmate saying that another inmate said something. There has to be something that corroborates that. And there's nothing that corroborates that. There's no evidence offered by the defendant with regard to that. So as we stated in our pleadings, both in our motion in limine and in our response to this reconsideration, that the law is very clear and there's not enough here for that alternative perpetrator information to come in.
All right. Thank you, Mr. Coleman. You want to reply to that? You
Yes,
may.
Your Honor. There again, I think that statement we gave the court in the original motion to dismiss, and I don't want to reveal the gentleman's name, but it's a record. He made the comment that the night before Chantelle Humphries was killed, that Lanny Alexander told him that there were people on his brother's farm riding ATVs, and that he told this witness that his brother told him to mind his own business. You couple that with the fact that Mr. Alexander is not in custody, and you couple that with the admissions against penal interest. We don't expect Mr. Alexander to come and admit to that. He's going to have to be impeached. But we think it gets us solidly into the realm of alternative perpetrator. Thank you, Judge.
Counsel, I haven't looked at it closely enough to have a decision, even after factoring in your arguments today. And on all these pending matters, obviously time is of the essence at this point, so I will look at it. Mr. Stewart has given me more than I had before, so it is worth a relook, and has not, from the Commonwealth standpoint, has not changed the Commonwealth's position. So I will review what you have given me to look at and get a decision out on this issue as quickly as I can then.
Your Honor, do you need that statement? I think you gave it back to us.
I made good notes
Okay,
on it
very
and
well.
may have kept a copy of it, I'm not sure.
Because we didn't play it at the hearing, we
You
just
didn't. I
tendered
took it,
to the court for it.
and I haven't looked lately, but I'm pretty sure I kept a copy myself, so, all right. All right, so that's firmly in my court to work on. The next thing was your notice of intent to introduce evidence about victim prior sexual history and related items. So why don't you speak to that, please?
Yes, Your Honor, and as I indicated to the court earlier, we filed that motion out of an abundance of caution. The first trial, we were not looking at a rape charge. And under the rape shield law, which I've researched to find out it just went into effect around the time of this offense. Under the rape shield law, Judge, there are certain things that we must give notice before we can even have a chance of introducing it. So I filed a motion giving notice of our intent to follow the rape shield law rules. But I also, as I indicated to the court in chambers, this is the exact reason why we asked the court to dismiss this rape charge, because we believe the rape charge was brought by the Commonwealth to gain a tactical advantage. And the tactical advantage is to limit our ability to offer this jury evidence that bears upon the guilt or innocence of my client. And there was testimony at the prior trial, Your Honor, that was not objected to by the Commonwealth. In fact, the Commonwealth even offered some of the evidence as to the victim's sexual habits or proclivities. And now we can't use that under the rape shield law because they added an indictment for rape. We filed for a bill of particulars, and the Commonwealth responded generally that the rape charge is based upon what the Commonwealth believes was evidence of a struggle within the car and evidence of semen within the victim's vagina. Now, take issue, there was no evidence of semen found in the vagina. The evidence of semen was found on the victim's panties. The Commonwealth also is arguing that the force can be gleaned from the footprints of the victim inside the car, which was on a rear window, I believe, or a side window. Your Honor, we just don't believe that that's sufficient evidence. I'm sorry, I lost my... We just don't believe that that's fair to now add the Rape Shield Act and put it into play to prevent us from showing that this was not a rape, that she had relations with people in exchange for drugs.
And that's based on testimony that came in the first trial.
Okay. So that's, and I just did that, Your Honor, out of an abundance of caution, because we still would like to have the right to offer this evidence to the jury. And before I can do that, I had to file that motion.
You did. All right. It does change the shape of that testimony with the new charge. Mr. Coleman.
Well, irregardless of the new charge, I don't think that evidence is really relevant to the fact of whether this defendant murdered Chantelle Humphries. We think that the evidence shows rape, and that's the reason we went to the grand jury and asked that grand jury to bring that charge. And as we stated in our original responses to the motion to dismiss, that's for the jury to decide at this point. So we've gotten past that. But frankly, what they want to do, what the defendant wants to do, is to continually defame the victim in this case to make her less likely of a victim in the jury's eyes. That's all they want to bring in. The fact that she had relationships, if she had relationships with other persons, what's that got to do with the fact that this defendant murdered her? Nothing. The fact that she used drugs has nothing to do with this case. He doesn't try to, in his statement, to put those together in any way. And to try to say, well, she had sex with other people, which isn't relevant in this case, has nothing to whether or not a footprint is on near the roof of his car. That shows a struggle. So as the Commonwealth has stated in our response to the 412, none of that is really relevant to what happened between these two individuals on that morning in question. And as such, try to get into things that happened days before or months before or problems between her and her husband have really nothing relevant to what happened when this defendant had her in his car, took her out, and shot her.
Thank you, Mr. Coleman.
If I may, Your Honor,
you may.
the reason that the other evidence is admissible, we believe, is because she used her sexuality in order to get drugs. In this particular case, now that my client's charged with rape, there was evidence at the previous trial that she used my client in order to get a favor from him. And as you recall, the evidence was that she asked my client to give her a ride in order to take her car to get it fixed. And then said my client was nice and she wanted to do a favor for him. And that's when the sexual activity came up. We think that goes to the heart of our defense, that it was not force. And the fact that she would have sexual relations with others in exchange for some type of consideration, for lack of a better phrase, Your Honor, goes to whether or not my client raped her on the day in question. Again, that wasn't an issue back in the first trial. It became an issue when the Commonwealth chose to launch an indictment against my client. And we believe they only did that to gain a tactical advantage. Thank you, Your Honor.
All right. Thank you both on that. And same situation, they have not met my own goal of having looked at the appropriate cases that you've both given me and a couple of others to the extent that I'm ready to rule on that today.